Welcome to Lawyerpreneur, where we discuss the alternate paths that allow lawyers to engage their entrepreneurialism and distinguish themselves from others, because being a lawyer doesn't have to mean doing business as usual. I'm your host, Jeremy Richter. Today's episode is brought to you by Alps Insurance, the nation's largest direct writer of lawyers' malpractice insurance. Founded for lawyers by lawyers over 30 years ago, Alps works directly with your firm, no broker or agent, and if you do have a claim, the Alps claims handling team is comprised of actual attorneys, all with private experience. Alps roots for the law firms they protect. They believe in your success and nurture your endeavors with industry-leading coverage, risk management resources, and accredited CLEs, offering practical advice for pioneering lawyers like you. And Alps has the slickest online application out there. Qualifying firms can apply, see rates, and bind coverage in about 20 minutes. Right now, you can get 25% off one CLE seminar from Alps. Go to alpsinsurance.com/CLE. That's ALPS insurance.com/CLE and use the promo code LawyerPreneur upon checkout. In addition to the corporate sponsorship that helps pay for the hosting and transcription of the show, you can support Lawyerpreneur on Patreon at patreon.com/lawyerpreneur. For less than the cost of a .1, you can help pay for the time it takes in creating and editing Lawyerpreneur and receive copies of my two most recent books, Stop Putting Out Fires and Level Up Your Law Practice. Now, on to the interview. My guest today is Becki Lee, an intellectual property lawyer with Seyfarth in Atlanta. She was previously on episode 27 of the show to talk about her children's book about intellectual property, Do You Draw Pictures? And she's back today to talk about how we as entrepreneurs, whether you have just a side hustle or some business venture that you're setting out on totally apart from law, can protect our intellectual property. So Becki, welcome back.
Thanks for having me.
You're the first return guest. How do you feel about that?
It's an honor.
All right, so let's start with you.
Okay.
You've written a book, Do You Draw Pictures, and created a brand that the book falls under, Little Gavels. So let's just start with what you've done to protect your IP assets and why.
Okay, so the first thing I did when I wrote my first draft of Do You Draw Pictures was I registered that as a literary work, an unpublished literary work with the Copyright Office. And the reason I did that is because you get some extra damages if you ever have to sue for copyright infringement. You get some extra remedies if you have registered your work within 90 days of it publishing. And so I thought better to just go ahead and do it now, even though it's not published, and have that official document on file. And then once we had the finished book, I also registered that basically as a joint work with Walter as the artist. And so he owns rights to the visual aspect, and then I own rights to the literary aspect. And you kind of limit the written part that was already registered. So that's all done. And then as far as trademark goes, you cannot actually register a trademark for a single title. But because the Little Gavels book series is going to be a series, you can register that mark as a series of published works. So I won't be able to register Do You Draw Pictures as a trademark, but I have applied to register Little Gavels as a trademark.
And another thing we did, and I sent over some notes to you, and I didn't think about this until just now, is so I published the book under my publishing imprint, Scarlet Oak Press. And when we set about contracting it, something that we were both on the same page about that I don't think we knew we would be going in is that you wanted to retain the copyright for the book. Whereas traditionally, like my first book that I published through the ABA, they own the copyright. And when you publish a book with traditional publishers, they buy the copyright from you. But you wanted to retain that. Why was that important to you?
It was important to me because I knew I would want to do other things with that content eventually. For example, we want to do some videos, and I might want to do, I don't even know. I don't I guess that's the point. I don't know what I'm going
Yeah.
to want to do
You
with
want
it in
those
the future.
options.
Yeah, exactly. And also I think, just really depends on what kind of business relationship you have, but I can see where, if there, I think we talked about this on the last episode as well, but if there's a, not necessarily an imbalance of power, but the ABA has a lot more money that they can just kind of do things with. And so if they're offering you a lot of money to buy your copyright,
They don't.
then oh, they don't. Well, look, I'm not going to critique your deal that you have
Yeah.
with the ABA, but they did probably have a little bit more bargaining power.
Yes.
So, it's easier to do that, especially also, for example, if you're an employee of a company and you create something for that company, they automatically own that. They don't even have to get a written agreement from you if you're a full-time salaried employee. So there are a lot of different situations where it's not a big deal if you sign your copyright away. But in this case, it was mine and I didn't know totally what I wanted to do with it. So I would have rather just held on to it. And in the same vein, Walter has also retained the copyright to his illustrations. And so I have an exclusive license for now. I can't remember if it's perpetual or not, but if he wants to do other things with those drawings, he can. So, it's just a matter of there are a lot of different factors that go into that decision.
Okay. So in general terms, we're talking about books here, but intellectual property obviously is much broader than that. And this is going to be a super open-ended question, but why is it important generally to protect your intellectual property, whether it's copyright, whether it's trademark? I don't think we're going to get into patents and trade secrets and all that, but why is that an important thing for us to be mindful of?
Well, the main thing is to protect it so that other people don't come along and make money from it or use it in a way that you wouldn't want them to use it. And so, one important thing to note is that you can't protect an idea. So, a lot of people say, oh, so and so stole my idea. Well, there's not really any kind of IP where you can protect an idea, but you can protect the implementation of that idea, which usually, you've put a lot of thought into and creativity into the expression of that idea. Or you have a solid business plan, you've got that going for you, so you file an intent to use trademark application, something like that. Basically, once you've taken enough steps beyond your idea that you have something concrete and exploitable, you want to be able to protect that so that someone else doesn't come along and profit from the work that you've done and the creativity and the originality that you have.
All right. So most of the listeners are lawyers. This is a show for lawyers. You and I are lawyers. We tend to think, rightly or wrongly, that we can generally handle things on our own. I'm probably the poster child of someone who has done all of the intellectual property things wrong or slowly or backwards, either because in the early days I wasn't mindful of it, or just because there's 1,000 other things going on. So should we handle this sort of stuff on our own, whether it's trademark or copyright, or should we consider hiring an intellectual property to help us protect our assets?
It depends on the scope of the IP, I would say. Um, if you're starting your own firm, you could conceivably go in and file your own trademark application. That being said, I spoke to a guy once who said he'd filed his own trademark application for his firm and was telling me all about how it was a huge pain in the ass because he had to, file to protect his trademark for business cards and stationery and all this other stuff. And I said, you don't need to protect that stuff with your trademark application. That's incidental. You just need a trademark for legal services. And he said, well, no, that's not true.
Mm-hmm.
Okay. Well, I'm sorry you spent so much on filing fees.
Yeah.
But you can go in and you can very easily type your firm name and, choose legal services from the list, from the trademark ID manual, and just fill out all the, fields on the online form and file your trademark application. You could do that yourself. But I would at least talk to an IP lawyer to figure out, do you need to do a clearance search? If it's your own name, chances are, it could be fine, but you just never know. So it's always good to at least talk to somebody and kind of issue spot with them, and then decide if you want to do it on your own. Copyright, same thing. I know I already told you need to register all your books with the Copyright Office.
Yes. So,
and you could do that.
For admission here is that despite having 3 books in print, or I guess 2 that I've published, and then another one that's on the way. Yeah, I haven't filed for copyright protection with any of them yet.
Yep. It's okay though. It's okay because copyright is automatic, and the registration, you really need it for lawsuits. So it's not a huge deal, but it's just, an extra thing that you should do, kind of like an insurance policy, which maybe is more in your speaking your language with that.
Sure.
But you could do that yourself. It's like, I think it might be $65 now or $55. You just create a login at the Copyright Office. You choose what kind of work it is, etc. And they have little pop-ups that tell you, to give you more information about, if you have a question about this field that you're filling out. It gets more complicated if you have joint owners, or it's a work made for hire, or it's been assigned to you. Then, you want to talk to a lawyer to sort those issues out. So if you're just doing, one-off trademark applications and copyright applications, you could probably fake your way through those. But I would definitely talk to somebody. But then if it gets to be a bigger thing, then I would hire somebody. So if you have 3 or 4 trademarks and, you're licensing one of them, you definitely want to talk to a lawyer about that. If you have a whole series of things you want to protect with copyright registrations, I would definitely get a lawyer to walk you through that. But, for the easy stuff, yeah, it's kind of like, I'm not an estate lawyer, but when we were flying to Canada, I realized we didn't have a will, and we were about to go to a different country and leave our kids behind. And so I went on and got the, OCGA will template, and I just filled it out. And I had the paralegal at my firm at the time was a witness. And, so I kind of faked my way through it, and I have a thing, and it's, valid. But I know that I need to go hire an estates lawyer eventually to have a real will written. So, in its simplest
forms, like a will, like you could probably wing it and handle it. But if it starts to get more complicated or convoluted, talk to somebody.
Call somebody.
Call somebody. Right. And you'd mentioned trademarking a firm name, which honestly, I don't have my own firm, so that hadn't occurred to me before. But I guess whether it's a firm, whether it's any other type of business, there's, I've started a couple of businesses, and you have ideas for what you want to call it, and you go through 1,000 different options. And early on, it did not occur to me that before finally settling on a name that I liked, I probably should make sure that isn't already registered and is someone else's mark. So, so this episode is just going to be all about the things that I didn't do right that other people should. At what part of the process of naming your business should you start to look and see if that name is available or already associated with somebody else?
Well, My answer is going to be different than someone else's answer for sure. My answer is come up with 10 names that you like, rank them in order, send them to an attorney and ask them to do a knockout search for you. And at that point, the attorney can go through, hopefully quickly, depending on what their fee structure is, can go through and say, this one's available, this one's a little bit risky, this one's low risk, et cetera, et cetera. And they can kind of help you narrow it down. What most people do is they come to you and they say, this is the name we've chosen. Can you make sure it's clear?
Mm-hmm.
And then it usually is not. And so you have to tell them it's not clear. And then they say, well, what kind of a risk am I looking at? And then you have to really evaluate, is this other party going to come and sue you? Or, what are we looking at right now? A lot of times it's like an old mark that somebody's not using anymore. And you have to go through a whole analysis of what you really want to deal with. So I love it when clients send me a list of 20 marks and they say, here's what we've got. These are the 3 that we love. Can you help us? And so I'll start with the 3 that they love. And if none of them are available, then we start going back through the list. So it's a huge pain in the butt, but it's a lot less expensive to do that up front than it is to just be married to something and then you realize it's not clear and you have to go back to the drawing board, or even worse, you have to totally rebrand a year into starting your business. So yeah, I would say as soon as you've narrowed it down to 5 to 10 options, that's when you should talk to a trademark lawyer.
All right. So you talked about various risk levels. I assume that means it can mean various things, but the first thing I thought of is there's somebody else using that mark, but it's in a different field or a different line of business than what you're doing. Is that kind of what you're talking about?
Yeah, there are a lot of different factors that go into the analysis. It could be that it's an identical hit, but they're not really using it anymore, or it's a close hit and they're in a different state and neither of you are advertising your goods or services outside of your state. Or it's an exact hit with services, but it's a slightly different mark, or vice versa. So sorry.
No problem.
I got a landline when the pandemic started, and I don't even know how to turn it off.
I don't think that I've ever had a landline as a, grown up adult here. I'm pretty sure about that. That's kind of weird.
We have the way I have my office phone line is through Jabber, and it forwards to my cell phone. And that's the only way I can get calls on my work line. And so if the internet is spotty, it doesn't work. So I have it forwarding to a landline now.
Interesting.
Yeah. So anyway, where was I? Oh, okay. So yes, another situation where the risk is high is the other person is offering the exact same goods or services, but the mark is slightly different. Or like you said originally, it's the exact mark, but the goods and services are slightly different. So there are a lot of different facts that can affect your risk level.
All right. So I assume you can have the same potential issues with a logo. We've been talking about names. Do the same things arise with the logo?
Yeah, definitely. But more often than not, the logo is kind of descriptive of the services, or is not highly stylized where you would need to search it separately from the words. So yes, you still want to clear it, but the issues are a lot different.
Okay. And I'll give a different kind of example, and this is going to go to licensing that may attach to logos. Is for my second book, Stop Putting Out Fires, the cover artist, Carrie, we went through several different potential image or different covers that had different images that she had purchased through Canva. And Canva and other groups like it have different licensing rights, and you can purchase different packages and different licenses attached to it. And she purchased the license that would allow us to use those images on a book cover or in the interior of the book. But I, again, another learning opportunity here, or mistake. I started using one of those images on my website apart from its use in the book. And so on the cover of Stop Putting Out Fires, there's a guy who's got like 6 arms because he's juggling, 100 different things. And so I was using that, and then she and I talked about some other things, and she was like, hey, you need to make sure that you have the rights for the way you're using it. So I went back and looked at the licensing agreement, and sure enough, I couldn't use that as a logo or anything that would in any way intimate that it was a logo or a brand or anything like that. So if you use stock images from Canva or other sites, you do need to make sure that you have the appropriate license for the way that you want to use the image.
Yeah. And I personally am not a fan of using clip art in a logo for that reason, because whatever is on the internet, like unless you're clicking a box that really has explicit license terms and you know for sure what they are, it's hard to know. Like, a lot of people will go and get what they think are Creative Commons or free images, and they're not. So it's better to even just go on one of those, I can't remember the names of the sites, but where you hire somebody to create your logo for you.
Yeah, Fiverr
Just
or 99
exactly.
Design, right?
Yeah, exactly. So that they're assigning it to you outright, and it's yours forever to use however you want. And so, yeah, it's kind of a weird crossover with copyright and trademark, but what you want in a trademark is something that you can use forever, because that's the advantage of trademark law, is you own the rights to that trademark for as long as you're using it. So you could potentially own that trademark forever. I mean, think about the Quaker Oats guy, or, there are 100 logos, the Coca-Cola logo. Like, if Coca-Cola had used clip art in their logo, they've been using it for how long? I don't even know. So you want to be able to use it forever. So I would have a designer do the logo, assign all the rights forever to you. They don't retain anything. And then you can use that logo anywhere you want.
When should you register your various intellectual property? Like you mentioned with your copyright, that you did it as it was a work in progress and certain rights attached to it. For a trademark, should you register before you start using it? Or if you name your business and like start operating, like, can you do that before you register? What's the best order? If there's a best, it may be that there's not.
There's not a best. I would say it depends on, of course, I started this sentence with it depends, but it does. It depends on, first of all, whether you have a bona fide intent to use the mark, because you have to check a box that says, under penalty of perjury, you have a bona fide intent to use that mark. So, for example, all of the people that go and apply for the latest catchphrase to use on t-shirts, which that's not even trademark use, I doubt any of them have bona fide intent to like launch a business using that latest catchphrase. And so you really have to have concrete business plans before you go and file that intent to use trademark application. That being said, once you do have something in mind, that's a good way to go, because if you're in a very competitive industry, for example, we have a gaming client who they want to file for the name of their new product as it's in development so that somebody else doesn't beat them to the punch, because their lead up time to launching that is so long. that they want to go ahead and reserve the name now, and then you can maintain that intent to use application for up to 3 years. So if you're in that kind of situation, you want to file it way ahead of time. If you're a small business and you're not even in commerce in terms of like under federal law in commerce, across state lines, et cetera, if you have a comic book shop and you only operate in one town in Georgia and you don't sell to anybody, you're not, on a highway where customers are coming in from out of state, you probably don't need to file a trademark yet. But then if you start expanding, then you do want to go and file a federal trademark application. So it just depends
on do like any internet business, right?
Yeah. Yeah, you definitely want, if you're shipping your products across state line, you want to have trademark application for that. That being said, if you've only made 2 or 3 sales online and you don't have $300 lying around, or $1,000 if you're hiring an attorney, then wait. I would still do your own clearance search, just to make sure nobody else is using it, so you don't have to rebrand later. But you can probably wait until you've established some rights and then go file your trademark application.
All right. So the bona fide intent to use caused me to think of a question, or 2 different questions that I don't even know if you'll have answers for this. I remember that back around like 99, the late 90s, it had to have been, and I don't know why this sticks out to me. Somebody had registered a mark for 21st Century Fox, because that was obviously the next evolution for 20th Century Fox, which they later changed to Fox Searchlight or whatever it is now. Is that a valid mark for some just like random person to have registered that if they don't have any real intent to use it?
No. And it's the same thing with there was a recent example where somebody applied for something to do with the royal family and filed like 20 trademark applications, and he was going to sell them to the royal couple or whatever. No, that's fraud. Don't do it. It's very common in other jurisdictions. For example, we have to file applications for our clients' trademarks in China all the time because they're a first to file jurisdiction, and you don't have to have an intent to use the mark there necessarily. Now, you have to prove use later on once you get it. But if you beat somebody to the trademark office there, you're now a squatter and you can sell just like people do with domain names all the time. So it happens all the time here. But if you apply for a trademark hoping that the real owner is going to come and buy that from you, you're going to get stopped in a number of ways. You could get a fraud claim against you. Or if the USPTO recognizes, for example, in your example, they know that there's already a registered mark for 20th Century Fox. 21st Century Fox is confusingly similar, so that application could get refused. There's also a device that I use a lot called a letter of protest, where if you see a new application that's filed, but the PTO hasn't examined it yet, you can send a letter to the PTO that says, this is confusingly similar to my registered trademark. Make sure you look at that before you examine it and consider that. And so that's another way that you can kind of stop those people.
All right. So here's my other question that you handled that one really well. So I trust your ability to handle this one because this happens from time to time. Earlier in the NFL season, Kyler Murray, who's the quarterback for the Arizona Cardinals, threw a Hail Mary at the end of the game, and they won, and it was amazing. And so I think it was the Twitter hashtag, but a word that caught on, or a phrase, was Hail Murray, on account of Kyler Murray and Hail Mary. And so I saw that a couple days later that his team of people had, registered that phrase Hail Murray to try to protect it. What rights does something like that actually protect or provide them? Does it keep people from being able to use that on like shirts or hats or whatever you might want to put on it? How does that work?
Yeah, it could. The hashtags like that are kind of a gray area because it could be, just informational or whatever. It's not really a trademark use if you're just using it as a hashtag in a tweet or whatever. And also when you're putting a phrase on the front of a t-shirt, that's also not really trademark use, although sometimes those get through. For colleges, for example, if you have the name of the college on a t-shirt, the PTO generally will deem that a trademark use because you're kind of saying this t-shirt is associated with that university.
Sure.
But for the most part, t-shirt designs are considered merely ornamental and not trademarks. And in terms of the team having the rights to that hashtag, it really depends on, yes, I think the PTO probably would give that to the team if they were legitimately using it in connection with merchandise. But again, it's kind of ornamental, so it's a gray area, and I think it would depend on which examiner you got. But if other people are trying to register that, the chances are it'll either get refused or the team is going to go after those people.
Okay. Good job. All right. So this is my last set of questions that I had on the actual topic that I intended to ask you about. And that is, all right, you had mentioned earlier that if as an employee you create a product, then that product belongs to your employer. And then, so I guess a similar type question is, I work for a firm, I have these side businesses that I'm doing. Do I, or why do I need to avoid using any of my firm computer or any other firm property to work on my other businesses? And I know what the answer is, that you should avoid it because of an episode of Silicon Valley that I watched. But I don't know the why behind all of it.
Sure. So it's funny because it's actually borrowed from, I think, an employment case. There's an analysis. So let me go back to the statute, because you always start with the statute. The Copyright Act says that a work made for hire, which means it's different from an assignment because no rights can revert. A work made for hire means that the creation belongs to the entity from the moment it's created. So the entity is basically the legal author. So it's different from an assignment where you create it and then hand it over to somebody. So the Copyright Act says a work made for hire is something that is either created by an employee within the scope of their employment, or it's made by written agreement and is one of these 9 types of things. We're not going to get into that second part because it's a mess. But the first part, the question of whether you are an employee and whether you created it within the scope of your employment, comes from employment law. There was the leading case on it. I don't remember what year it was, but it's CCNV versus Reed. And they run through a number of factors of what is within the scope of your employment. So if the employer controls your tools, the method, the process, if it's, during work hours, if you're salaried, if you're, in the office when you're doing it. So it's all of those factors that you would use to determine if someone is either an independent contractor or a full-time employee. And so whether they're an employee and whether it's within the scope. So if you are writing a brief on your home computer at night for your law firm, the factors go both ways, but ultimately it's probably going to show that that's within the scope of your employment. even though you didn't use your employer's tools, blah, 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 as part of your job, they own copyright in that argument that you just drafted. So, on the other hand, for example, I even asked my boss about this just to be safe, but I wrote, "Do you draw pictures?" on my laptop at night, mostly on the weekends. And it's not within the scope of my employment to write a children's book. So my employer has no claim to the rights in that book. On the other hand, if I'm writing an article to promote something that has to do with my job, that is probably, especially if I do it on my computer at the direction of my boss, where he's reviewing it, proofing it, etc., that is something that would be a work made for hire.
All right. That's really helpful. All right. And some of the topics we have talked about here have come up in other episodes of Lawyerpreneur. And so I'm going to put those in the show notes. But in episode 16, MC Sangaila talked about learning how to be a client when she was working with her IP lawyer, and that was a very different role and a difficult transition to make. And then in episode 31, Haley Altman talked about when she was getting ready to launch and worked on her business that has now merged with Latera. She talked about making sure that everything was done on her own devices and not her firm devices. And so I'm going to put those episodes in the show notes to make sure people can know where to find those. But I think this was a really useful and productive conversation, and I appreciate your time.
Thanks for having me.
Thanks for listening, and I hope you've enjoyed today's show. Please take time to rate and subscribe at whatever podcatcher you're listening on. And if you want more from me, you can find me at jeremywrichter.com. You can also find me on Twitter at RichterJW. And if you want the extra audio and benefits available at Patreon, you can become a patron at patreon.com/lawyerpreneur. Thanks for listening.